Hi, my name is Lourdes Brown. I'm with Indivisible 845, and I'm reading the article Be Prepared to Challenge Penalty Assessments, written by Mindy, also of Indivisible 845. It's important to be forewarned about the administration's latest act of cruelty. Now, as you pick up your daily mail, you could find a letter from the government assessing an enormous penalty, which could be anywhere from several $1,000s to hundreds of thousands of dollars. The recent policy is loosely based on laws passed by Congress in 1952 and 1996 that were never enforced until Trump's first term. The 1952 law imposed a fine when there was reason to believe that a person had violated any of the provisions of the Immigration and Nationality Act, INA, and the 1996 law permitted the Department of Homeland Security, DHS, to order payment of a civil penalty of up to $500 per day, now $988 after adjustment for inflation, for each day that a person willfully failed or refused to depart from the United States after an order of removal. These laws are subject to a 5-year statute of limitations. In 2017, President Trump issued an executive order to ensure the assessment and collection of all fines and penalties from non citizens unlawfully present in the United States. During his first administration, Trump issued 233 notices, of which 26 individuals were ultimately fined for a total of $4,215. The Biden administration rescinded the executive order. On his first day back in office, President Trump issued a new executive order reinstating the collection of penalties. In May, the White House issued a proclamation for DHS to conduct a nationwide communications campaign to notify certain non citizens of the consequences of remaining in the United States. These penalties, which are assessed at the rate of $998 a day, can add up to approximately 1.8 million under the 5-year statute. On June 9th, 2025, DHS announced it had issued over 9,000 notices. Later in June, the administration issued new streamlined procedures allowing DHS to serve non citizens with a notice of intent to fine through regular mail rather than in person or via certified mail. It also shortened the time for non citizens to appeal a notice from 30 to 15 days and bars non citizens from requesting an in person interview as part of their appeal. These procedures also fail to define what constitutes a willful failure to depart. Litigation. On November 20th, 2025, two immigrants and a nonprofit organization filed a federal class action lawsuit against DHS and other government actors, alleging that the Trump administration has unlawfully imposed ruinous civil penalties pursuant to federal statutes in an attempt to convince immigrants to voluntarily depart the United States. And this case was Maria L. versus Nome. The complaint alleges that the government has failed to complete individual assessments before assigning fines in violation of federal statute. The complaint also alleges that these fines are unconstitutional under the Excessive Fines Clause of the Eighth Amendment and the right to jury trial under the Seventh and Fifth Amendment. Finally, the complaint alleges that DHS violated the Administrative Procedures Act by failing to undergo notice comment, acting arbitrarily and capriciously, and exceeding the agent's legal authority. Challenges. There are several defenses upon which you can refute receipt of a penalty notice. These fines are generally issued without providing any finding of willfulness, which is the premise for the assessment. For instance, there could be various reasons for an individual's failure to depart. The person could be under supervision of U.S. Immigration and Customs Enforcement, or ICE, and is or has been reporting to ICE. An attorney may have filed a motion to reopen removal proceedings, or you may have been incapacitated and prevented from departing. Any of these circumstances indicate that you were not willful in your failure to depart. There are also several constitutional challenges, including the absence of procedural due process, the right to a jury trial, and the excessive nature of the penalties. Legal representation. Anyone with an outstanding deportation order needs trusted legal representation. An attorney can help you proactively respond to an outstanding removal order and react quickly should you receive a penalty notice.